We have a history comment, one of my favorites. This commenter is saying, funny how since Trump took back the Democrats' special court now, it's partisan or needs expanded because you can't get your whack ideas passed through the ballot box. Oh, how fun. Let's take a little walk down memory lane when it comes to the U.S. Supreme Court. I will happily walk you through the 15 courts that we've had since the founding of our country. Now, there were a lot of cases that were decided by all of these Supreme Courts. I've picked out the ones that are my personal favorites. The very first Supreme Court was the Jay Court, and it was in 1789, and it may be best known for the Chisholm case. This was the case where the U.S. Supreme Court said that Georgia needed to show up in court if someone was suing them. Afterwards, the 11th Amendment was passed, and this was no longer law. But that's the very first Supreme Court. The second is the Marshall Court, which you may be familiar with, Marbury versus Madison. This was in 1801 when Marshall took over as Chief Justice, and this particular case set out that the U.S. Supreme Court is the one that's going to decide what the Constitution means. So they gave themselves the power of judicial review. And since that case, we now have what we currently view as the Supreme Court reviewing all constitutional questions. Next up, in 1836, we have the Taney Court. Probably the most famous case out of this was the Dred Scott case. This case was one of those cases where they decided that it didn't matter how far removed your ancestry was regarding race. If you had any percentage of a particular kind of race in your system, you were considered not white and therefore did not have the privileges that the white people had. So number 4 was the Chase Court. This was in 1864. Now, there were several things going on, of course, with the Civil War, but one of the most interesting cases was the Bradwell case, in which the U.S. Supreme Court said that women are supposed to stay at home and have children and raise those children because that's God's way and are not supposed to be practicing law. A personal favorite case of mine. Next, in 1874, we have the Waite Court, and it said here in a batch of cases, the civil rights cases, that Congress is not allowed to prohibit discrimination based off of race. Not allowed. It's unconstitutional. Next, in 1888, we have the Fuller Court, very famous case, Plessy versus Ferguson, where it said that separate but equal was fine. So segregating the races was absolutely fine under the Constitution. Next, we have 1910, the White Court, where we have the Dagenhart case that was passed. This is very famous because it struck down the idea of any kind of child labor laws. So child labor protections were not allowed. They were seen as unconstitutional. Next up, we have in 1921 the Taft Court. Now, Chief Justice Taft was also president, the only president and Chief Justice. Now, one of the most famous cases out of the Taft Court was Buck v. Bell, in which the U.S. Supreme Court held that forced sterilization of a woman in a mental health institution was fine. That was allowable under the U.S. Constitution. Next up, in 1930, we have the Hughes Court. Now, there were a lot of things going on in the Hughes Court, and we kind of turned a little bit of a corner. We had a minimum wage for women that was allowable. We had fair labor standards that were allowable, and a minimal price for milk was also allowable. So several things were kind of moving forward under the Hughes Court. But then, in 1941, we have the Stone Court, which famously decided the Korematsu case that said if you have any Japanese ancestry, even if you are American, you need to go to particular internment camps if you're located in certain places in the United States. All right, we're almost there, everybody. The 11th court is the Vinson Court, and that was in 1946. Most famous case is when they said to the president, look, you can't stop labor unions from doing what they're going to do just because you're president. So he couldn't stop the steelworkers strike based off of an executive order. Very interesting case. Next, we've got number 12, which is the Warren Court, and this was in 1953. There were a lot of cases that came out of the Warren Court. Brown versus Board of Education, which did away with segregation. New York Times versus Sullivan, that had to do with freedom of the press. We had Cooper versus Aaron, which had to do with whether or not states have to listen to the United States Supreme Court decision to desegregate. We had Loving versus Virginia, which made it so it didn't matter what races you were, you could get married. Katzenbach, which as well as Heart of Atlanta Motel, which was whether or not different kinds of private or small businesses could discriminate against people based off of race. Lots of cases came out of the Warren Court, and that's just a few. Next, in 1969, we have the Burger Court, most famously known for Roe versus Wade. Next, we had Craig v. Boren, and the Craig v. Boren case ultimately held that when the U.S. Supreme Court is considering if there is gender discrimination versus race discrimination, gender discrimination will always be lower or have a lower standard of scrutiny at intermediate rather than strict that race has. Very interesting out of the Burger Court. Next, we've got the Rehnquist Court in 1986. Now, of course, the Casey case and Roe were overturned later on by the Dobbs case. It just happened a couple years ago. But Planned Parenthood versus Casey put some limits on the Roe versus Wade's rights when it came to women's privacy rights when they're pregnant. Next, we had the Prince case, and the Prince case did away with background regulations that Congress had put into place under the Brady Act in order to run background checks for people who were trying to get hand weapons. So background checks, are they universal? Nope, because of the Prince case under the Rehnquist Court. Then next we had the Perry case, which said if you want to put the 10 Commandments up on government property and that's part of your history and tradition, sure, that's fine. So no problem, Texas, on your government property, you can have the 10 Commandments. There's no problems with freedom of religion and church and state separation there. That takes us then, everybody, to the Roberts Court, which is the current court that we have right now. And we had the McDonald case that came out of that, which basically said, now the Second Amendment applies to all of the states, and it's almost unlimited, almost completely unlimited, that right to bear arms. So good for you, Second Amendment. Next, we have the Burwell v. Hobby Lobby case, which said that businesses can discriminate based off of their own religious beliefs when it comes to healthcare options. Next, we had the Citizens United case, which also said unlimited amounts of campaign contributions and no accountability and no need to actually know who's contributing to these different kinds of campaigns either. Completely up to whomever would like to do that. So no regulation pretty much at all when it comes to campaign contributions. And then last we have the Dobbs case, which took away a woman's right to make decisions about her own personal health care and put in place this idea that somehow the government has more information and is in a better position to decide what's best for a woman and her health care and her family. So when you're asking about trying to switch this court because it used to be Democratic, I'm wondering exactly what you're talking about. If you mean liberal, perhaps you're talking about that one time when the Warren Court put out a few different individual right cases, or perhaps you mean the Hughes courts back in 1930 where a couple of their cases went to the general welfare of all of the people in the United States. But other than that, it's been a conservative court. It's been a conservative court since the beginning. So I'm not really sure what it is that you're talking about here, but I'm glad to have an opportunity to clarify. We've had 15 United States Supreme Courts since we started this country. And out of those 15, there was a period in the 50s and 60s with the Warren Court where individual rights took precedent. Other than that, it's all been the court reversing pretty much almost all of those rights that were granted under the Warren Court. So hopefully this kind of gives you some insight into the history of the United States Supreme Court.